We're now in custody and live streaming, or we're now on record and live streaming here at Thurston County District Court for the in custody calendar. So, yeah, Miss Capone in the Thurston County Corrections Facility, I believe.
Yes, thank you, Your Honor. This is Mr. Stowe, number 12 on the 1:30 calendar.
And we're here for a preliminary hearing. Mr. Stowe, so you're Canon James Stowe?
Yes.
And what is your date of birth? Okay, all right. And let me turn to your attorney there, Ms. Capone.
Thank you, Your Honor. Mr. Stowe and I discussed his rights, and I believe he understands them. We're not contesting probable cause for today's purposes, and we'll ask the court to appoint counsel from my office going forward. I have provided the court with a good phone number and mailing address.
All right. So on that, finding probable cause, I'm going to determine what release conditions or possible restrictions on your behavior, Mr. Stowe, that I'll be setting. I'm going to hear from the prosecuting attorney. I'm going to hear from Ms. Capone on your behalf. And I will appoint Thurston County Public Defense to represent you after today as well. And first off, Ms. Kitmacher, on behalf of the state, what are you asking of the court?
Yes, Your Honor. The state is requesting $5,000 in bail, a no contact order, and no firearms or dangerous weapons based on statements the defendant made noted within the police report, threats to kill the entire family, the victim's family, in front of the daughter that they share. Defendant admitted to officers that he wished someone would die. And I also have confirmation that the victim is in support of the no contact order.
And that's Christy Scott, the alleged crime victim?
I believe so, Your Honor.
Okay. And Ms. Scott, you look like you're present on Zoom.
Yes,
is there anything you'd like to say? You don't have to say anything, but is there anything you'd like to say?
I would just like to say I would agree with the protection order.
Okay. What I'm being asked to sign here says that Mr. Stowe would not come within 1,000 feet of you or your residence or your workplace or school or wherever you are, and not contact you in any way, shape, or form. And this would be a court order and could not be changed unless a judge changed it. And a violation of it could be another criminal law violation. So that's what I'm being asked to sign. No contact of any kind. And that's what you're asking for?
Yes, please.
Right. And is that the shared child or your child?
Are you asking me? Sorry.
Do you have children in common with Mr. Stowe?
No. Justice Scott Stowe, this is his only child. Not biological, but on birth certificate and parentage.
So do you have children in common is what I was asking.
Oh, no, ma'am. No.
No. Okay. All right. So, Ms. Capone?
Your Honor, we'd be asking that Mr. Stowe be released on his own recognizance today. I would note a very limited criminal history. Much of it was from when he was a juvenile. And with regard to the no contact order, we would be asking that there be an exception for either electronic communication regarding childcare or having third-party contact for childcare. Mr. Stowe indicated that his mom already mediates between the parties. And Mr. Stowe represented to me that their 18-month-old is a child in common. And it sounds like from the statement of Ms. Christie there that he legally is a parent of the child, given the fact that he's on the birth certificate. So we'd ask that he be released on his own recognizance, acknowledging the fact that these are just allegations. He is entitled to the presumption of innocence and the presumption of release. And we would ask that there be some type of third-party contact to allow Mr. Stowe to see his child.
So, Ms. Scott, a child in common means that you both either share biology with this child, or a court has found that there's an adoption or something. So is this child produced by the two of you, or did a court adjudge this as Mr. Stowe's child as well? Oh, you're muted, so I can't hear anything you're saying.
Sorry. I muted you so we didn't hear the crying baby. But so he is on the parentage form that was signed at the hospital of birth. But that was the only.
Okay. All right. That means that there you go. That's a presumption that this is his child.
I would go ahead and like to make a few notes now if I could.
Okay. So I'm not going to make any decisions essentially about this child. That's for the Superior Court. But
okay.
Obviously, a decision about this no contact order that affects you is going to affect an 18-month-old that cannot contact its putative father on its own.
She has not really had much contact from him. I mean,
yeah,
she's
I'm not asking
day.
you about the contact. I'm not making decisions about who has this child. I'm not making decisions about, custody or anything of that nature. I'm just trying to figure out that if someone's name is on a birth certificate, you are the presumed parent. And that's where we are. And it's presumed that you have a child in common then. Now, if you have other ideas about what should happen with this child, that's for the Superior Court to make a decision about, not the district court. So, all right. Anything else, Ms. Kitmacher?
No, Your Honor, just reiterating the concerns of the state based on the statements noted in the police report.
And Ms. Capone, anything else?
Your Honor, I would only just reiterate that it sounds like Mr. Stowe's mother was already mediating contact between the parties originally. That's why I think third-party contact might be best here.
All right, so Mr. Stowe, the allegations are that you made, this is charged, or it's not charged, but it's here as a prelim in the misdemeanor court. And from what I read in the probable cause, potentially this could be charged as a felony. Repeated threats to kill and harm the family with a belief of immediacy by the family and by Ms. Scott. So I am going to set several restrictions on your behavior to keep the community safe. One of those is I'm signing this no contact order. And for now, I'm not going to make any exception at all. The child was present and subject to some of these harassing statements. So I'm not going to allow in this order any contact of any kind with Christy Joy Scott. You stay 1,000 feet from wherever she lives, works, goes to school, wherever you know she is. You don't contact her. You don't contact her through family, through friends, through social media. Now, Ms. Scott is the protected person, and she is not entirely in control of this order. It only changes if a judge changes it. So even if Ms. Scott were to invite you to violate this order, sir, you're the one who gets arrested, put back in custody, and possibly charged with new crimes. And you do not possess any firearms going forward. You surrender any that you have. You don't possess any going forward. As well, I am given what I've heard in the probable cause and read in the probable cause here, given some warrant history going a ways back, I'm going to have you post some bond to ensure that you come back and ensure that you don't violate this court's orders. 5,000 cash or bond will have to be posted. If you post that, then follow this no contact order. Don't possess a firearm. Don't violate the law. And we're going to set a court date here in case this is charged in this court. Let's see. And that will be on the 10th of April. What time would I set that? 8:30. 10th of April at 8:30. And I'll set that as an arraignment date. You've got Thurston County Public Defense to represent you going forward.
Okay, well,
Right. So that's all for today. And then Ms. Scott, if you want to be in touch with prosecutor's office, crime victim advocacy, you can also be in touch with public defense, but they're limited. They can't really talk to you unless Mr. Stowe allows it.
Okay. Okay. Thank you.
You're welcome.
Love you.
Love you.
Don't you mute her?
Your Honor, to clarify, public defense was appointed.
Yes.